Good morning and welcome to the BRR Legal Brief, looking at the major legal issues affecting Australian business. I'm David Bushby, and today we've taken the show on the road for the very first time today, broadcasting live from Allen's Arthur Robinson here in Melbourne. Today we're talking about the global crackdown on bribery and corruption, and here to discuss why and how this can affect Australian business is Rachel Nicolson, who's part of the International Business Obligations team here at Allen's. Welcome, Rachel.
Thanks, David.
Rachel, bribery and corruption in certain parts of the world were, I guess, until now, generally regarded as being part of doing business in those countries. Why the crackdown?
Really, it's an issue of enforcement. I understand your comment. Certainly in some parts of the world, for some businesses, it was considered necessary to do business, to make small payments to government officials or sometimes larger payments to either government officials or people in the private sector. But what we're seeing now is an increase in enforcement, not just of the domestic laws of the countries where the payments are made, that enforcement is on the rise, but also, and perhaps more importantly, of the domestic laws of home countries of businesses, for instance, the domestic laws of Australia, the UK or the US that have extraterritorial reach. So we're seeing a lot more regulatory action on that front.
Absolutely. Well, the sirens are definitely ringing out loud. And I just wanted to look at, I guess, around the world, some of the hot spots that you see where Australian businesses could come unstuck if they continue to buy into that culture of payment and favours.
Interesting question. When you think about hotspots, I think it's important to understand it in two contexts. One is, of course, geographic hotspots. There are certain emerging economies and developing countries where the risk of bribery is significant. That's particularly the case in some countries in Asia, China, India, some other countries in that region, and also, of course, some countries in Africa. So we're seeing at the moment a remarkable mining boom in and around Africa, and certainly some of those countries present real risks. So that's the geographic hotspots. But then you also need to think about legal hotspots, and they come in a variety of forms. One is, as I've already said, these domestic laws, Australian laws, UK, US laws, etc., that have extraterritorial reach. That means, in effect, that no matter where you're operating in the world, you can be subject to these laws under the jurisdiction of your home country.
I just want to also look at the concept of facilitation payments. And for the viewers that don't know the difference here, I wanted to ask you, what is the difference between a facilitation payment and a bribe? And will Australia ban facilitation payments as they have done in the UK?
Another interesting question. Under Australian laws, a facilitation payment is supposed to be a minor payment to obtain or to expedite a routine government act, like provision of a visa, provision of a security clearance, something like that. The distinction that you could draw between a facilitation payment and a bribe is that with a facilitation payment, there should not be an intention to obtain an improper business advantage. That said, it's important to understand that a facilitation payment is probably illegal in the country in which it's being made. And that is one of the key drivers for the UK having banned facilitation payments under its new Bribery Act. But importantly, the Australian government having released a discussion paper on considering banning facilitation payments or removing it as a defence from our criminal code. Because that discussion paper is out there, there is a very strong possibility that it will be removed from our criminal code.
Well, just on the UK Bribery Act, I want to look into that a little bit because some legal experts are describing that new act as being frightening. What are your thoughts there?
It's interesting, there has been a lot of discussion around the UK Bribery Act going around the traps. I wouldn't say so much that it's frightening, but I would certainly say it has raised the bar in respect of international compliance standards. First and foremost, the UK Bribery Act clarified the extent to which UK laws apply, and that includes the extent to which they apply extraterritorially. That was ambiguous under the previous legislation. But insofar as their reach, they've had some very interesting bar-raising results. One is that, yes, facilitation payments aren't provided for. So if you're subject to the UK jurisdiction, you should not have a policy or compliance program that allows for facilitation payments. Another is that the UK Bribery Act goes into the private sector. It's not just about bribing foreign public officials, it's about bribery in the public or private sector, full stop. Most importantly though, and this is the aspect that people think of as frightening, is that there is a strict liability offence for failing to prevent bribery. It's important to understand, though, that offence includes a defence of adequate procedures. So if you can show that you have adequate procedures to prevent or minimise this conduct occurring, then you will be able to argue that defence under the Act.
And Rachel, you mentioned the consultation paper about the banning of facilitation payments. There's also another consultation around the National Anti-Corruption Plan. How does all of that fit in with what we're talking about today?
It fits in quite neatly. Australia, at the end of last year, released its National Anti-Corruption Plan, and it's undergoing a consultation process in respect of that plan. The plan is aimed at strengthening Australia's addressing of anti-bribery issues or bribery issues both in Australia and offshore as relevant to Australian interests. It's important to understand that Australia has received some criticism over the last few years in respect of its meeting its obligations under the UN Convention Against Corruption and the OECD Convention on Combating Bribery of Foreign Public Officials. That has been particularly in respect of the enforcement of its anti-bribery laws. So what is a clear theme in the anti-corruption plan is an intention to increase enforcement of these anti-bribery laws.
And Rachel, I guess just finally tying this all together and saying what we've just said, what would be your number one tip for an Australian business operating in a high-risk jurisdiction?
If you are operating in a high-risk jurisdiction, in particular jurisdictions like Asia, Africa, the Middle East, or countries within those regions, then my strong advice would be put in place an anti-bribery policy and a robust compliance program that is properly enforced so that you do have a strong argument that you did have adequate procedures in place and that you had, for the purposes of Australian law, a corporate culture that did not tolerate or facilitate this sort of improper conduct.
Well, a great tip and some fantastic insights. Thank you again for your time today, Rachel.
My pleasure.
And viewers, thank you for tuning in. We look forward to having your company for next week's Legal Brief.